Good day. Our topic for today is Anti-Wiretapping Act as governed by Republic Act 4200. So what is covered under the law? It provides that it shall be unlawful for any person not being authorized by all the parties to any private communication or spoken word to tap any wire or cable or by using any other device or arrangement to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone, a dictagraph, or dictaphone or walkie-talkie, or tape recorder, or however otherwise described. So if you notice, the person that can be made liable here are anyone. Anyone in the sense that he secretly record by tapping any wire or cable in order to secretly overhear, intercept, or record such communication. Now, there is an issue of what constitutes private communication, or will it include to private conversation? Is there a difference between conversation from communication? They are actually used interchangeably. And it is private in the sense that it is actually between the two of you. Now, there is a violation if the offender failed to get the consent of all the parties, because it could be possible that the offender here, or even the offender here is the person who secretly record their conversation without even informing the other person on the line, or there is someone who record the communication or conversation with the consent of one but without the consent of the other. Would it still be subject under the law? Yes, because the law says not being authorized by all the parties. Now further, if you notice here, the interception here of the conversation or communication, aside from the fact that it could be committed by tapping a wire or cable, it would also be possible that the same is recorded with the use of a dictaphone, dictagraph, or dictaphone or walkie-talkie, or any kind of tape recorder for that matter. Now, there is also that question on whether or not the overhearing or listening to a private communication through an extension line of a telephone constitutes a violation of this act. It was ruled that the same is not covered, considering that there is no such thing as tapping or recording for that matter, but just merely listening by the other person on another line, which is a thing that he did not tape record or through use of any device, as that extension, or can we say party line for that matter, when we have the old model of the telephone, they are not actually covered under the provision of the law. Now further, the other act constituting a violation of this act is that when any person, he or be a participant or not in the act of acts penalized in the next preceding sentence, he knowingly possess any tape record, wire record, desk record, or any other such record or copies thereof of any communication or spoken words secured either before or after the effective date of this act in such a manner prohibited under the law. In other words, the mere possession of this communication covered under RA 4200, the person who is possessing it is still punishable under this act. It says here knowingly possess any of this communication, or if ever he reply the same for any other person or persons, or communicate the contents thereof, either verbally or in writing, or to furnish transcriptions. What do we mean by transcriptions? You have there the communication and you had it transcribed. So naana ka, you already have there the lyrics or the written words based on the recording. Provided that the use of such record or any copies thereof as evidence in any civil or criminal prosecution or trial for offenses mentioned under section 3 hereof shall not be covered with the prohibition. So meaning to say, if the act of the accused is for purposes of the prosecution of a criminal case or a criminal investigation or in a civil case, then the same is not covered on this particular portion on the act described under this particular paragraph of RA 4200. So to reiterate, the act Spanish under Article our Republic Act 4200, you have there secretly overhearing, intercepting, or recording private communications with the use of or by means of devices enumerated. So there must be that device connected or used in order to record or intercept such private communication. Knowingly possessing any tape record, wire record, desk record, or any such other record or copies of any communication or spoken word taken in a manner prohibited under RA 4200. Replaying, communicating the contents, and then furnishing transcription of complete or partial. So I'm just reiterating, numbering them in such a way that it would be easier for you to know the Act Spanish under section 1 of 4200. Now, when we say top, there must be a wire or cable or use of a device or arrangement for purposes of secretly overhearing, intercepting, or recording the communication. That's why in an extension of a telephone, it cannot be placed in the same category as a dictaphone, dictagraph, or the other devices enumerated in section 1. There must be showing of deliberate installation of a device or arrangement so as to overhear, intercept, or record the spoken words or private communication of the individuals without getting the consent of all the parties subject to the communication. Section 2. Any person who willingly or knowingly does or who shall aid, permit, or cause to be done any of the acts declared to be unlawful in the preceding section, or who violates the provision of the following section, or aids, permits, or cause such violation shall upon conviction be punished by imprisonment for not less than 6 months nor more than 6 years with the accessory penalty of perpetual absolute disqualification from public office if the offender is a public official at the time of the commission of the offense. And if ever the offender is an alien, he shall be subject to deportation proceedings. As an exception to the punishable acts provided under RA 4200, you have there an exception to a peace officer. If he is authorized by a written order of the court to execute any of the acts declared to be unlawful in the 2 preceding sections, especially if it involves the crime of treason, espionage, provoking war and disloyalty in case of war, privacy, mutiny in the high seas, rebellion, conspiracy and proposal to commit rebellion, inciting to sedition, kidnapping as defined under the RPC, and violations of Commonwealth Act 616, punishing espionage, and other offenses against national security. These are justifiable reasons wherein a peace officer may be authorized in writing by the court to execute the acts prohibited under RA 4200 without making himself vulnerable of a possible prosecution under this act, provided that such written order shall only be issued or granted upon written application and the examination under oath or affirmation of the applicant and the witnesses he may produce, and a showing that there is reasonable ground to believe that any of the crimes enumerated herein above has been committed or is being committed or is about to be committed. Hence, the court shall issue such authority to the peace officer. Provided, however, that in cases involving offenses of rebellion, conspiracy, and proposal to commit rebellion, inciting to rebellion, sedition, conspiracy to commit sedition, and inciting to sedition, such authority shall be granted only upon prior proof that a rebellion or acts of sedition, as the case may be, have actually been or are being committed, that there are reasonable grounds to believe that evidence will be obtained essential to the conviction of any person for or the solution or to the prevention of such crimes, that there are no other means readily available for obtaining such evidence. Meaning to say, the applicant peace officer has to justify to the court the need of recording such conversation against a particular suspect or accused. So when shall the court issue? So you have there the requisites. An order granted or issued shall specify, meaning to say, if the court is convinced on its necessity, the order shall specify the following: the identity of the person or persons whose communications, conversations, discussions, or spoken words are to be overheard, intercepted, or recorded. And in the case of telegraphic or telephonic communication, the telegraph line or the telephone number involved and its location. Next, the identity of the peace officer authorized to overhear, intercept, or record the communication, conversation, or spoken words. In other words, the order has to specify who among the peace officer is authorized to do the recording, the offense or offenses committed or sought to be prevented, and the period of the authorization. The authorization shall be effective for how long? Not to exceed 60 days from the date of the issuance of the order unless extended or renewed. All recordings made under court authorization shall, within 48 hours after the expiration of the period fixed in the order, be deposited with the court in a sealed envelope or sealed package, and shall be accompanied by an affidavit of the peace officer granted such authority, stating the number of recordings made, the dates and times covered by each recording, the number of tapes, the discs, the records included in the deposit, and certifying that no duplicates or copies of the whole or any part thereof have been made, or if made, that all the duplicates or copies are included in the envelope or package deposited with the court. So this is how the peace officer shall make a return to the court of the order granting them to do the recording. Now, what shall the court do when it received the envelope or the recordings? The envelope or package so deposited shall not be opened, or the recordings replayed, or used in evidence, or their contents revealed, except Upon order of the court, which shall not be granted except upon motion, with due notice and opportunity to be heard to the person or persons whose conversation or communications have been recorded. The court referred to in this section shall be understood to mean the regional trial court within whose territorial jurisdiction the acts for which authority is applied are to be executed. So what are the possible questions on RA 4200? What constitutes wiretapping? So basically, when we say tap a wire or cable or recording or intercepting with the use of a device or an arrangement. And then take note of the fact that an extension telephone is not the wiretapping or is not wiretapping constituting the prohibition under 4200. What are the exceptions? So of course, you had there the act of the peace officer who is doing a surveillance or a criminal investigation against a person or persons charged with those offenses classified as crimes against national security. So you have there the authority to be issued by the court. And then communication or conversation. So as what I have mentioned earlier, for purposes of applying RA 4200, they are used interchangeably. That's all, and thank you for your time.